This Parliament should pass Bill C-62 as quickly as possible and prove to Canadians our commitment to equality and social justice.
The Minister of Employment and Immigration last week stated to journalists that the feminist movement should deal with the basics and leave aside less important aspects of the problem. I think that this is a golden opportunity for her in this context to integrate into Bill C-62 elements which women, handicapped, visible minorities, and the handicapped consider essential.
And within the positions they do occupy, inequity of salary, 64% of what men make for doing the same work to be exact.
Trying to get into hire disabled people because, in fact, the record of business in hiring disabled, in fact, historically, hiring women on an equal basis has been absolutely abysmal.
No, it
so
hasn't.
in that sense,
no, I don't know where you're getting your data.
The only reason why...
Maybe Afghanistan or something, but not Canada.
No.
Even today, there is little value in opposing the threat of a closed society by imitating its arbitrary restrictions. Even today, there is little value in ensuring the survival of our nation if our traditions do not survive with it.
There's been a story going around about the British Labour Party charging white men more for tickets to an event. The article says that last night the pricing was blasted by the equalities watchdog, who hit out that charging people different rates because of their race is unlawful discrimination. The Equality and Human Rights Commission added, "We will be writing the Labour Party to ask them for their justification for this policy." Labour still has questions to answer as to how such an illegal and irresponsible proposition could have been adopted in the first place, and they also owe an assurance it will never be repeated. An article from The Atlantic reads, according to a document first reported by the New York Times, the Trump Justice Department has decided to focus on investigating and suing universities with affirmative action programs that the department deems to have discriminated against white students. A spokeswoman added, the Department of Justice is committed to protecting all Americans from all forms of illegal race-based discrimination. The Justice Department pursues cases of intentional race-based discrimination all the time, but those cases are almost entirely cases where minorities are the subjects of discrimination. So what these two articles are telling me is that unlike Canadian law, direct discrimination against whites is illegal in these two countries. I'm going to show you that not only is discrimination against whites legal, it is actually mandatory under the law.
Employment equity is what we have in Canada. Affirmative action is in the States. Affirmative action has quota, employment equity does not. All employment equity does is to make sure that all the processes are fair in terms of the hiring, and actually they look at promotion and salaries too. There are other components the Employment Equity Act looks at. But all they do is want employers to try their best to hire and promote underrepresented members. If I remember correctly, maybe 2001, 2002, the federal government did have this thing about hiring 1 in 5. 1 of every 5 hirings have to be a member of a visible minority group, and they did not meet that target. I felt really bad for that lady who applied and got kicked out because of that. Because she checked that she's white Caucasian and because she's a woman. But that is something that I think a lot of visible minority Canadians face all the time. May not be as blatant, as direct.
In 2010, the Globe and Mail ran a story called "Tories Take Aim at Employment Equity." The move came in a response to a story of a Caucasian woman who tried to apply for an administrative assistance job in the Federal Ministry of Citizenship and Immigration, only to find the competition was restricted to Aboriginals and members of a visible minority. Such a practice is permitted under the Charter of Rights and Freedoms and is intended to help government meet diversity hiring targets. While judges would likely be split onto whether or not this does actually break the law, that is, precluding women specifically, Subsection 2 of Section 15 states that equality provisions do not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national, or ethnic origin. color, religion, sex, age, or mental or physical disability. My Canada includes everyone who belongs to the 4 designated groups. On the face of it, the Canadian Human Rights Act would seem to protect race and gender from grounds of discrimination, but further details within the law explicitly overwrite those rules. When read correctly, the Employment Equity Act actually makes discrimination mandatory. The Act states that employment equity means more than treating persons the same way, but also requires special measures in the accommodation of differences. The Act requires employers remove barriers to employment that disadvantage members of the 4 designated groups. Examples of employment barriers are practices that make members of a designated group uncomfortable. Examples of positive policies include job advertisements in a Chinese language newspaper. With the introduction of Bill C-16, gender expression and gender identity will also fall under the Human Rights Commission, and thus the Employment Equity Act will soon adopt, if they have not de facto adopted, gender identity and gender expression.
With Carolyn Kay, a lawyer with Hicks Morley, to talk about pay equity compliance.
And so they have to achieve pay equity, and there's a whole host of steps that they have to go through, identifying what the job classes are in their organization, determining their gender dominance, and then rating the jobs to figure out which jobs are of comparable value. And then at the end of the day, adjusting their wage rates accordingly. And certainly, as I say, the liability can be significant.
What is the Pay Equity Commission doing now that could affect employers?
For the most part, complaints have always been coming into the Pay Equity Commission, so they've always been very active. But what they've been doing more recently, presumably to generate business, is they've started what they call as the wage gap, the gender wage gap program, which they send letters off primarily to private sector employers asking them to send in information with respect to their wage rates and so on and so forth. All under the guise of research, and so there's a live issue about whether or not an employer is compelled to send in that data. The downside is if you don't send in that data, they will come knocking on your door in any event to see if you're in compliance.
What are the hidden costs of non-compliance?
The biggest is the fact that there is no time limit under this legislation, and therefore anyone can come forward now and complain. It doesn't have to be a current employee, it can be a past employee, it can be a union even if they've signed a deal. And if you're an organization that was supposed to have done this back in 1990, you're looking at retroactive adjustments back to that period of time. And now the big kicker is the interest rate. Because they will attach interest to the sum that's owing, and they will apply the interest rate that was to be in effect at the time of the plan. So in 1990, for example, the interest rate that will be used is 12.5%, which is obviously much higher than it is now.
This is one I've run into in my personal life: women only, Asian only, or Muslim only housing ads. There's a 2-bedroom basement apartment for rent in Toronto, posted on Kijiji. Typical caveats: no pets allowed, no smokers, and then a less common request: only Muslims need apply. It's the exact kind of specifications the Ontario Human Rights Commission recently warned about. But for all its condemnations of the practice, the Commission said this week that they can't police these online ads and that it's out of their hands, and they also don't police it in practice. Instead, a person would have to call up the prospective landlord and file a complaint if it was clear that they were not considered for the apartment because they weren't Muslims, for example, or were Chinese, Korean, or Japanese, as other Korean Craigslist Vancouver ad said it would prefer successful tenants to be. And that one I've literally had happen to me. I actually became woke on this issue after I kept printing out a resume at a Asian-owned pharmacy in Vancouver and handing them out and not getting calls, and printing them and handing them out and not getting calls. The Asian pharmacist told me that was what was up. I got turned down a job on the A&W on Main Street and Commercial Drive, Vancouver, BC, for not speaking Punjabi. Toronto City Councillor says Muslim-only subsidized housing is acceptable. A Toronto City Councillor sees nothing wrong with the policy that allows the exclusion of non-Muslims from subsidized housing in the city. We want people to live in a culturally appropriate setting, said Councillor Joe Cressy.
I would ask you to think about people who are handicapped. Many of these individuals are now out in the community, ready and willing to work. However, they are faced with a 50% unemployment rate. 50%. And I think that's most unfortunate.
But those people we saw in the beginning talking about feminism, the wage gap, and social justice in 1985 were actually the opposition to this bill. They wanted mandatory employment laws.
One of the options recommended by Judge Abella in her report.
There are areas in which I don't think that this bill goes far enough. And I say this without malice, Mr. Speaker. I say this in the sense that these groups who indicate that they feel that the government's response to the Abella report is far too meager and far too small to discuss here this morning are groups that represent the majority of women in this country. I'm talking now about the National Action Committee on the Status of Women, who have indicated their complete dismay at the meagerness of the government's response to the Abella report. I'm talking now about the Canadian Labour Congress, the Urban Alliance on Race Relations, and the Canadian Congress for Learning Opportunities for Women. These are groups, Mr. Speaker, I might add, that represent the majority of women in this country. They indicate, these groups were the same groups that appeared before the Abella Commission, indicated, and they represent the women, the disabled people, and members of visible minorities in this country. They indicated the need for mandatory affirmative action programs to overcome the inequalities that women experience in the Canadian labour force. And those mandatory affirmative action programs must be backed up, they've said, by strong and effective enforcement procedures if we are to see progress towards equality. And therefore, Mr. Speaker, one of the very first things that they find wrong with the Bill C-62 is that the government has not opted for mandatory affirmative action programs.
Judge Abell in her report said we need mandatory affirmative action. The Americans have been saying that for years as well.
Dispose of the said stage of the said bill shall be put forthwith and successively without further debate or amendment. Is it the pleasure of the House to adopt the motion? All those in favour of the motion will please say yea. Yea. All those opposed will please say nay. Nay. In my opinion, the yeas have it. Call in the members.
And it's go, boys, go. They'll time your every breath. And every day you're in this place, you're 2 days nearer death. But you go. Well, I'm a process man am I, and I'm telling you no lie. I work and breathe among the fumes that trail across the sky. There's thunder all around me, and there's poison in the air. There's a lousy smell that smacks of hell and dust all in me hair. And it's go, boys, go. They'll time your every breath. And every day you're in this place, you're 2 days nearer death. But you go.